Good morning, Facebook family. So I'm doing this Facebook Live from my personal page. Normally, I would prefer to do this in my business page. So we're going to talk a little bit about business. My name is Erji E.J. Lee of E.J. Lee Law Practice, where the motto is to be creatively legal and to be a pink elephant in your industry. So I discuss all things copyright, trademark, some patent things, and things in pop culture. And I was tagged in two videos, two posts today. One post was about Beyonce and her ongoing legal fight over her daughter's name, Blue Ivy Carter, with a wedding event planner. So apparently it might be going to litigation. So we'll see what we'll talk a little bit about that. You know, it's nothing overdrawn. And then the last thing we're going to talk about is about Chicago Step, or Step in general, and its history with copyright and trademark. Let me see if I can tag Karen, because I told her that I was going to how do I tag people? Give me a second. Where's Karen? Where are you, Karen? So anywho, I was tagged in a video today of a young lady who has a podcast called Talking Tea with Keita, I believe it is. And she was talking about an uproar over Chicago Step. Heck, if you're black in urban society, pretty much you know about Step. It's a huge popular dance in black culture, and it's done all over the country. We do Step in Detroit, you do Step in Chicago, you do Step just about anywhere. I've stepped from time to time, but it is a huge community of folks that do Step. So apparently in this particular video, they were talking about a Chicago Step event that happened. And I guess a guy, I don't know if he is a DJ or somehow he is involved in the Step community. And apparently he stepped on stage and said that he had received a trademark registration for the use of the name Chicago Step. And apparently it was a big uproar about this. And the audience was very upset because, again, this is a very close-knit community. And I don't think it should be tied to one person, but we'll get into the legalities of that. So after I watched a little bit of the video, I decided to go digging into records because, again, I'm a trademark attorney. I do this day in and day out. I'm constantly checking records as it relates to trademarks, and you got to have receipts when you're talking about these kinds of things. So after I was informed that he supposedly said that he registered the trademark registration for Chicago Step, I decided to go check the records. Just so you know, anyone can check the USPTO records if you know what you're looking for and where to look. So, went to the USPTO and went through some search records, and I just Googled or put in the search box Chicago Step. About 5 records came up, and only one of those records indicated that it was still in the registration process. It had not received an official registration number. I don't want to make this too technical as far as legally, but the point is, whatever this gentleman said in terms of that he has a registration for Chicago Step does not appear to be true. There was someone who tried to register a trademark for Chicago Step, but it looks like it was denied, and that was back in 2014. So there is no official record for someone having a registration for Chicago Step. So let's talk about trademark and how this works. The purpose of a trademark is to act as a source identifier, to distinguish between brands. It is simply a consumer tool to help us pick the products and services that we want. If you're going to use terms or names that are literally descriptive of what it is you provide, you're not going to be able to get a trademark registration for it. Why? This is the United States. It's the home of competitive business. And so no one owns a business idea. And so I'll give you an example. Let's think of the big picture idea as a grocery store, right? And then you have how many grocery stores? You have Kroger, you have Publix, you have Walmart, you have Target, you have Meijer. These are all different trademark names of stores. But of course, my mother's calling when I call her back later. But the big idea is a grocery store. Same thing for shoes. You have tons of different shoes companies. You have Adidas, you have Nike, you have Puma. Give me 1 second while I talk to my mother really quick. Oh, Jesus. Whoops, sorry about that. Anywho, so again, these are all different examples of the overall big picture, which is a shoe company, but you have several different companies, right? So the big idea, nobody owns that. So getting back to what we're talking about, which is Chicago Step. Step is the big idea, right? And it just so happens to be Step in Chicago. So there's a legal term that we call that, which is geographically descriptive. If I'm not mistaken, Chicago Step has been around for years. Years and years and years, to the point where it probably cannot be tied to one person. So because of that, it's that's probably why the one that I found in 2014 was not registered, because Chicago Step literally describes what it is. There would have to be some other creative name that isn't descriptive of the dance that would receive trademark registration. So for instance, another good example I like to use is what's been going on here in Atlanta with Slutty Vegan. Slutty Vegan serves vegan burgers, right? And for whatever reason, people still are losing their minds over Slutty Vegan. However, Slutty Vegan is overall right in terms of selling as it. But the point is, the only thing that Slutty Vegan owns is the name Slutty Vegan. And they're able to use that name to franchise in other places. The young lady, I think her nickname is Pinky. She owns 2 locations now here in Atlanta, plus the is going to be spreading it around the country. She's done a food truck tour, and probably will expand to her hometown. I think she's from Maryland. But I say all that to say, again, it sounds like this gentleman has not received a trademark registration for Chicago Step. And even if he was to file for it, it's going to be denied because it literally describes Step, and it's in Chicago, which means it's geographically descriptive. That name has been used for years in terms of all of the different events featuring Chicago Step. So more than likely, he's not going to receive a trademark registration for that. So what's the other thing that applies to dance and choreography is copyright. Copyright applies to books, dance, art, film, music, some furniture and software, and clothing. As far as the furniture and clothing, what gets copyright is that it has separable art elements that you can literally display on something else. That is what receives copyright protection. So with copyright, the item or the work has to be fixed in a tangible medium, like on video, DVD, on Instagram or something like that. It has to have some type of tangible medium to be able to tie it to a person for the purposes of copyright. And with dance, it's very hard to track that because people are dancing everywhere. You go to the club, people are doing different dances. So it just depends on how it's being used in terms of being able to exploit it monetarily. So for instance, with Fortnite has 2 dances that have been part of legal lawsuits or whatever. So you have the Carlton dance and the original creator, if you will, Alfonso, I believe his name is, from Fresh Prince, was suing Fortnite over the dance, but there were some issues in regards to whether or not he had standing to sue because he did this dance on Fresh Prince, and who owns Fresh Prince? NBC. So that there were some issues there into whether or not he had any standing to even sue over the dance. I think the other dance that came up, I cannot think of the dance name, but it was created by this young kid, and he was also suing Fortnite as it relates to that dance. I forget if it even has a name. I forgot. But so, to shortly recap, you can trademark or file for a trademark registration of a name for a dance. But like anything else, it cannot be descriptive of what it is the dance is. So in this case, we're talking about Chicago Step. If you're stepping in Chicago and it's literally step, you're not going to be able to stop other competitors from saying Chicago Step. They have to do something else with that to stick out. What else? And then for the purposes of copyright, again, it does apply to books, dance, art, film, TV, music. But it has to be fixed in a tangible medium. So some type of video. So for instance, if someone was trying to teach Chicago Step, people want to learn in the comfort of their own home, you could do a Chicago Step instructional video, and then someone can register the registration for copyright in that video and be able to sell it so that people can view it whenever they want to. But you better come up with a better, clever name versus calling it Chicago Step. Something else. Because Chicago Step is too descriptive of what it is that's being provided. Does anybody have any questions? Karen, I don't know if you're still here. So no need to be flipping out about whether or not this gentleman is going to be suing people over the use of Chicago Step. Because it sounds like when he was on stage, he presented some type of certificates showing that he owned the registration for Chicago Step, but it's as easy as going to the USPTO and checking the records to find out whether that's official, and it's not there. And what is there has been dead since 2014. So yes, Chicago Step is not a good trademark name if that literally is what it is that you're providing. However, I do agree with the gentleman that was in the video that people should protect their work. However, they have to understand what is the purposes of, the legal protections that we have in this country. Patent is the highest level of an intellectual property protection that you can get. Then you have copyright and trademark. The thing with patent is you get 20 years to be exclusive for whatever it is that you've created, and you can stop other people from making that particular design. But the trade-off is that after that 20 years, anyone is free to make it, and you have to provide a blueprint to the United States Patent and Trademark Office so that when that 20 years expires, those who are familiar with that particular area, science or whatever it is, would be able to make it without a problem. With copyright, the protection time is 70 years plus the life of the author, right? But the thing about copyright is, and this is one that's tricky. Say you have, this was an example that was given to me in law school of a tree. I'm looking at a tree right now, and two people have drawn the tree exactly the same. To come up or to prove copyright infringement, it takes two things: access and substantial similarity. If I've never met a person who drew the tree exactly like I did, we both have copyright, or we both have a work that is protected under copyright, and neither one of us would be able to sue each other. It's not like the patent law where if I have a patent registration for an item, if someone makes something similar to it or exact, I could stop. In that instance, you would be able to stop them because you have an exclusive license for that in all its forms for 20 years. But after that, that's it. And then anyone is free to make it. With trademark is indefinite as long as it's being used. So for instance, obviously the founders of McDonald's have been dead for years, but the name still remains, right? Because McDonald's is still in business. For as long as McDonald's is in business, they will continue to be able to use that name indefinitely. Believe it or not, I believe Abercrombie & Fitch used to be a safari clothing company, and they went out of business. But what they did was they sold the name to another clothing company. And now it has become all things for teenage clothing. But the point is, trademark has to be used, and it has to be consistent and continuous use, assuming it meets copyright, trademark parameters. It has to be something that is not descriptive of what it is that's being provided. Hopefully no one else is using it. So for instance, one of my favorite examples when it relates to a copyright that's strong is Apple. Why? Because Apple is not at all descriptive of technology or cell phones or anything like that. But it is literally one of the strongest trademarks out there. So, anyone who does Chicago Step that wants to do events doing Chicago Step has to use a different name associated with it. You can put Chicago Step in your flyers or anything like that, but you're not going to be able to stop other competitors from using that as well if that is what they provide. Another interesting example is this company called Trap Karaoke. And I saw an ad for Trap Karaoke a couple months back, and they were advertising because they had an event coming up in Atlanta. So I wanted to see if they had a trademark registration for Trap Karaoke. But then it dawned on me again, if you literally are having an event providing karaoke music or karaoke set to trap music, you can't stop other companies from saying Trap Karaoke if that's literally what it is that they're providing as well. So what they did was, instead of being on what's called the principal register, they are on the supplemental register. And now that's a little bit over people's heads, so I won't even go too far into that. But the point is, it's going to be very difficult for them to stop someone else from saying trap karaoke if in fact they are providing karaoke and it just so happens they're featuring trap music. Okay? So I hope that's clear. If anybody has any questions, please let me know. Again, this is EJ Lee of EJ Lee Law Practice, and I always like to burst bubbles around here in the trademark and copyright streets because people get in an uproar over things, and I'm just like, well, let me go check the records. The records always reveals everything I need to know, and then I can get people to like, calm down, it's okay, it's gonna be fine. You know, I mean, my thing is, if you want to find out whether or not you can coin a phrase or protect it, talk to a lawyer. Don't just go doing it on your own. And then, secondly, I'm wondering if that's some kind of fraud to be presenting official documents that aren't official. So you literally went and copied something? Did people even look at the certificates to see if it was real? Because just a little Google search, baby. No, sir. You don't own Chicago Step. It's been around for too long. Why do you think that you would be the only one to say Chicago Step? It's an amazing art form, if you ask me. We do this all the time. You know, I'm not the best stepper, but I know about step. My brother think he can step. He do a couple little moves and you can't tell him nothing. But that is something that is synonymous in our culture. You can't, no one person should be able to say Chicago Step or Detroit Step or Hawaiian Step or Atlanta Step. None of that. Hi, Marlon. So again, let's do a little recap. Copyright applies to books, art, choreography, music for sure, film, television, furniture and clothing designs where the art is separable from it. This sun is a trip. Trademark is a source identifier that helps us distinguish between brands. But if your trademark is too descriptive of what it is you provide, you cannot have a trademark registration because your competitors need to be able to use that if that is what it is that it describes. There are some trademarks out there that are so famous that they work too good. Believe it or not, escalator used to be a trademark. Trampoline used to be a trademark. Trampoline is by far one of my favorites because I'm trying to think, what did they call it before it was a trampoline? Was it a jumping apparatus? Like, what was it before trampoline? I'm just really curious to know. Roller skate used to be a trademark, which is interesting because it literally is a roller skate. What's another one? There are some that have worked too good that are being threatened to lose their trademark registrations. And another one, that would be Q-tip. How many people say cotton swab? Hand me a cotton swab. You say hand me a Q-tip. Kleenex. Hand me Kleenex. And that's facial tissue. Band-aid. How many people say bandage? No, you say Band-aid, which is why when you hear the Band-aid jingle, they always put in Band-aid brand because they want you to understand that Band-aid is a brand, that it's not what the item is. So, it's all things copyright, trademark, and bursting bubbles around here. So whoever this gentleman is, I would suggest that he not try to sue anyone for using Chicago Step in their advertising, okay? It wouldn't go well. Not to mention that trademark lawsuits are very expensive. So if you received a cease and desist letter talking about you can't use Chicago Step, just laugh. Because I would need you to show and prove. I don't know if he tried to get a registration in the state of Illinois, because you can get a state registration. Very rare that you would get that for a dance move. That would be really weird. But I always recommend state registrations for people who have no intentions of expanding outside of their home state. So like if you're a local restaurant that you have no intentions of expanding out of your state, it would make sense, and it's cost effective to do a state-based registration versus doing one all over the United States. And you have to do maintenance, meaning every so many years you have to refile to prove to the USPTO that you are maintaining consistent and continuous use. But I hope you guys found this information helpful. I would like to host a event where we just all come together and discuss things like what people are working on, what questions they have as it relates to your intellectual property and how to go about protecting it. I'm all down for stuff like that and connecting with people and seeing what people are working on. So if anyone is interested in doing that, please let me know. It would be something where we just kind of like get together, like maybe Panera Bread for lunch. And I get to know you, you get to know me. Most of you know I'm from Detroit. That's my hometown. Chicago is right next door. So glad you could come on, Latika. I'm sorry, please tell me how to pronounce your name. I would love to come on your show. Come on, girl, get me on there so we can expose these people. Not trying to be funny. But I mean, seriously though, that's just ridiculous that you would go through those kinds of okay, I love it. The tea lady. I like it. The tea lady. Yeah, well, we gonna drop this tea. Where's the rest of my coffee? So what I would like to do is I'm going to post in the comments the actual screenshot that I took of the USPTO records that anyone is free to check. And you will see that the last time that someone tried to file for Chicago Step was back in 2014. And next to it, it says dead. That means that for whatever reason, the registration was abandoned. They received something from an examining attorney that said, nah, you can't file for that. Or you need to present evidence as to why you think you should be the only one to use Chicago Step. For Step. Step. Literally in Chicago. Now I know Chicago Step probably has a couple different elements that's unique to Chicago. But again, if it's called Chicago Step, and I'm sure everyone has their own style or way of doing things, you need to come up with some other name that's unique to you. Even if you called it green grass and people are going to be looking crazy, that's kind of what you want, because it's going to stick to you. You have to use something that's not at all connected to what it is that you're providing. Hello, Apple. But yes, please post questions in the comments. I would love to meet up with some of you. And for those who can't come, we'll do a live where you can see what we're talking about and share. Let's get together. Let's connect, you know? Be our own biggest fans. But I will catch you guys on the next one. I don't see any questions. And I'll be sure to do this again. Oh, forgot. With Blue Ivy Carter. So, like I said, Blue Ivy, Beyonce is, for whatever reason, still in another legal fight with this lady who has had a registration for Blue Ivy for a number of years before Blue Ivy was even born. And so initially Beyonce lost the legal fight for Blue Ivy. So they changed it to Blue Ivy Carter, and it seems as if the same lady is not happy with that as well. I'm trying to figure out why she would have an issue with Blue Ivy Carter. So there's another concept called trademark dilution, but only super famous marks are allowed to employ this particular legal strategy. So again, one of my favorite examples is Starbucks. Starbucks stopped a lady from starting a company called Starbarks for dog hotels. Starbucks has no intentions of ever expanding into dog hotels. But because Starbucks is extremely popular, it is one of the biggest coffee brands in the world, if not, the universe. They can essentially stop other companies from starting different types of companies using a play on words type of name. And I'm pretty sure that lady did not have the resources to try to fight Starbucks on it. And so she abandoned it and let it go. But that's generally reserved for those who are super famous. And I'm pretty sure the Blue Ivy wedding planner lady is not nearly on the level of Starbucks to have a strong argument against Beyonce registering her daughter's full name instead of just Blue Ivy by itself. In fact, her legal team called Blue Ivy a cultural icon. Child is 5 years old and she's already a cultural icon? Okay. I mean, I get it, go hard for your client, but I just thought that was funny. So again, clearly this woman has money to burn because she's still fighting this years later. And from what I saw in the article, it's looking like it'll go into litigation. But I just wanted to throw that in there since I was tagged in that video as well. But hey, it's EJ Lee of EJ Lee Law Practice, where the motto is to be creatively legal and a pink elephant in your industry. If you want to do a one-on-one consultation with me, please go to my website at www.ejleelawpractice.legal, and I will catch you guys on the next one.